appeal in the matter of HMRC and Atholl House Productions.
Thank you. Yes, Mr. Tolley.
I'm grateful, Lord. As I hope my Lords already know, my name is Tolley. I appear with Mr. Stone and Ms. Tooton. Yes. Mr. Stone and Ms. Tooton were also in the case which your Lordships heard last week. And for the respondent is Keith Gordon and Camila Montes Manzano. Yes, I should say, my Lords, I hope you will forgive my presumption in suggesting that Mr. Gordon should sit in the same row as I.
Absolutely sensible, thank you.
Thank you, my Lord. So what I wanted to do first, and of course this is very much subject to your Lordships, is to propose an order of submissions and a timetable. I've discussed it with my learned friend, Mr. Gordon, and as I say, subject to your Lordships, it's been agreed. What's proposed is as follows, that I should open the appeal, but not make any anticipatory submissions with regard to the respondent's notice. My learned friend would then respond and open the respondent's notice points. I'd reply in relation to the appeal and respond to my learned friend's submissions as to the respondent's notice, and finally my learned friend would reply. I appreciate that makes 4 stages rather than 3, my Lords, but I hope that it would be more convenient.
Subject to anything my Lords want to say about that, that's fine. Would you like to lift the veil on timings?
Well, I hope there's not too much of a veil about it, my Lord, but what's proposed is that I would start now and go on until about 3 o'clock this afternoon, assuming that your Lordships would then rise at about 4:30, but it may be 4:15, of course it's a matter for my Lords. Then my learned friend would continue for the rest of the day and until about 1 p.m. tomorrow. I would then reply and respond in about an hour and a half till about 3:30, assuming that we broke at that point.
Well, you're comfortably within the timetable.
My learned friend would then have the remaining time to reply. My Lord, I certainly don't intend that should be rigid, and of course will be guided entirely by your Lordship.
Let's see how we get on.
I'm grateful to all of my Lords. The final thing I just wanted to check was that a supplementary bundle of 4 authorities was filed yesterday. I think 2 of your Lordships have it in hard copy. I'm grateful. And it's also been submitted.
Well, you'll see that, I'm afraid, there's a mixture of hard copy and electronic copies on the bench, so we'll get into a way of working and finding our way around, I'm sure.
Yes, of course, Mother. I've got references as required in terms of page numbers or
thank you.
PDF numbers. So, my Lord, if I may, I'd like to start with some overview points. I've got 6 of them. The first, which I hope isn't controversial in any way, is that the purpose of what's been called the IR35 legislation is to tackle a form of avoidance in relation to tax. I know my Lords have been referred to, and I can take my Lords there if it's required, the Professional Contractors Group case, which is in the First Authorities bundle. But it was made clear there by Lord Justice Robert Walker that the focus is to ensure that those who ought to pay tax as employees should not, by means of adopting a corporate structure, be able to change that outcome. And of course, my Lord, it's not suggested that every person who contracts through a company is thereby treated as an employee. One has to look at the substance of the underlying relationship. But nonetheless, that is the purpose. And I say that brings with it a corollary in terms of statutory interpretation. That is was summarised in Uber, and I can take again my Lords there as well, if need be. But the approach in that kind of, in any statutory interpretation context, but particularly in the context of legislation intended to tackle avoidance in the tax field, is whether the relevant statutory provision construed purposively was intended to apply to the transaction viewed realistically. And that's a quote from the judgment of Justice Ribeiro in the Australian case of Aratown assets. But it's quoted in Uber, if my Lords want to see it, at paragraph 70.
That's the standard approach to construing tax legislation these days.
And indeed perhaps to any form of statutory interpretation, my Lord. And so just drawing the final point through on this overview point, that the section 49(1)(c)(1), which is paragraph with which my lords are concerned uses the language of employee, but doesn't define it. And in the time-honoured sense, that imports the learning from the field of employment law about what is an employee. The second overview point, my lords, is what I submit is the importance, in general terms, of a...
Pausing
Of course, my lord.
Because small differences in early stage can magnify as they go along. You are or aren't suggesting that the purpose of the tax statute has any bearing on the definition of employee?
No, my lord, of course not.
You're not. So an employee is an undefined given element of the statute, but statutory interpretation purposive ideas don't bear upon whether somebody is or isn't an employee.
Yes, my lord, I would make 2 points, one by way of, as it were, agreement and one by way of, I hope, development. The agreement is that I'm not suggesting that one approaches section 49(1)(c) with any predisposition one way or the other. There should be no greater likelihood of finding employment or unlikelihood of finding employment. It's a matter of, for the law of employment. But the second point I would make, my lord, is this by way of development, that the idea of examining a transaction realistically is around in many areas of the law and is not something, as it were, special to what's been called an auto-claims approach in the field of employment law, or at least statutory employment rights. I just wanted to make that distinction, that looking at a transaction realistically is an element of statutory interpretation, quite apart from any question of special focus arising from it being a matter of statutory employment protection, as arose in auto-claims or Uber. The second point I was going to make, my lords, was about what I submit is the importance, in general terms, of the conclusion, one way or the other, about employment status. Because it not only obviously has import, as in this case, for purposes of tax, it also determines whether a person has or hasn't got certain employment rights. It's also relevant in the health and safety field, and it may have other implications. And so I submit to my lords that the same approach to identifying employment should operate across all of those fields. There shouldn't be some special rule for tax or employment or personal injury, as the case may be. The third general point I wanted to make, my lord, was about the nature of what's been called employment status. And in my submission, my lords, the status of a person as either an employee or not an employee is determined by reference to the particular work relationship.
By reference to the
Particular work relationship. It is not, in my submission, a characteristic which, once acquired, becomes immutable, or even presumptively so. My lords, I'm sure, will be familiar with the feature of working life, that it's a commonplace that people may move in and out of employment and self-employment and do different things at different times. And so what I go on to submit is that a history of working in one way or the other communicates nothing of any relevance about the current status in the context of a particular working relationship, save to this extent, that it may be relevant, and I put it no higher for the time being, to consider the history of the dealings between the parties, because that may shed some light on what they intended by the particular contract into which they've entered it for the time being. But what is unlikely to be relevant, or at least not to any great extent, is a history of dealing with others. And in my submission, my lords, there shouldn't be two different outcomes for people entering into the same contract at the same time with the same counterparty based on their career history with third parties. It just shouldn't make a difference.
I don't want to ask you to descend from what's a very helpful overview of these introductory points, but could you just let us know whether that's a proposition that you make, or a proposition that you will make good with reference to authority.
It's both, my lord. I'm not suggesting for a moment that there is an authority that says that, but I say that that is a proposition that one should draw from the authorities.
Right,
to which
so
we
you'll be showing us where that comes from, or where it derives support from in due course.
Of course, my lord.
Right.
The fourth overview point I would offer to my lords is this, that there is, at least in general terms, a need for consistency of approach in relation to the test of employment. What I mean by that, my lords, is that one should aim for what I will call a principled predictability of outcome. I appreciate it's impossible to achieve perfection in that regard. There are bound to be where different judges might reasonably come to different views. But the approach ought to be one where there is a greater prospect of being able to predict the correct outcome in advance. Now, there are a number of cases which I will show my lords for that proposition, but that's the general point, if I may, without getting into the cases at this stage. The fifth point, by way of overview, my lords, is that in my submission it must be possible in principle to classify a contract for work on the first day, or indeed prior to the first day. There shouldn't be different outcomes based on post-contract events, certainly not events external to the contract. In other words, the extent of work that one might or might not do for other parties. I appreciate, my lords, that in this field of employment, whether it's, as it were, employment properly so-called or something less than that, there are authorities which suggest that one can have regard to post-contract events in terms of shedding light on what it was that the parties agreed in the first place. But in general, I would submit, my lords, that one ought to be able to determine from the outset of a contractual relationship what its classification will be. And the sixth and last overview point, which perhaps take a bit longer, is just to explain to my lords, at least on my submissions, what I submit is not in issue in this appeal. There is a danger, if one reads some of the submissions, of thinking that this appeal is some kind of contest, on the one hand, between ready-mixed concrete and on the other, Holland Lorimer, and that your lordships are being invited to determine it. I would make it clear, my lords, that my submissions do not involve an attack on or a challenge to the authority of Holland Lorimer. As I say, I will show my lords in the authorities what might be described as a strong preponderance favouring the ready-mixed concrete approach. But there isn't any suggestion that Hall and Lorimer is wrong in the authorities. What I propose to do with my lords is, to the extent my lords can bear it, explore the interaction between those two approaches, the ready-mixed concrete and Hall and Lorimer.
Yes, I mean, as I understand it, you don't say Hall and Lorimer is wrong, but what you do say is you shouldn't mix and match them.
Well, if you do, you should be clear about what you're doing, my lord, in the sense that they do focus on different things in a different way. And it's important in my submission to be clear what one is about when you ask the different tests. But I just wanted to reassure my lords, insofar as such reassurance is needed, that there's no question of my lords being asked to depart from a previous decision of this court.
Are you going to say that they can effectively be synthesised?
There is a form of synthesis which is possible, my lord, but they do focus on different things, is going to be my submission. And so one has to understand the effect of that. What I would say, my lord, just by way of direct answer to my lord's question, is that perhaps the most likely solution in terms of synthesis is to treat the factors identified in Hall and Lorimer as factors relevant at the third stage of ready-mixed concrete. But I would say that that's a rereading of Hall and Lorimer, because that's plainly not what the courts at either level or any level were purporting to do.
But before we just, again, at a very, very high level, don't you then run into the difficulty that the Hall and Lorimer approach is much more expansive than you're going to tell us should be applied at the third stage of RMC?
I'm not sure that it is, my lord, more
All
expensive.
right, well, then I'll put that to one side until we hear you.
I can see that on some interpretations of it, it's been treated as more expensive. And I will address some of those factors, such as the one that emerged in this case as essentially decisive, as I would say at the very margins of relevance, or quite possibly on certain
That's
facts.
a
I would
point
say this is one of them.
It's not
Irrelevant.
really in issue. No contest between those authorities. Were you going to give us a list of things that are not an issue, or was that really the one?
Well, I just wanted to explain, my lord, how that's the main thing, I would say, my lord. But I just wanted to explain a little more about the genesis of the point, if I may, because I believe it will assist my lord. That there wasn't any such contest on the respective cases either in the first tier or in the upper tier tribunals. So in the first tier, it was common ground that the tribunal should apply the three-stage ready-mix concrete test. And the reference from my lords is paragraph 64 of the FTT core bundle, page 165. The FTT identified the third stage as follows: are the other provisions of the hypothetical contract consistent with its being an employment contract? And the reference from my lords is paragraph 64C, page 166. And just to draw my lord's attention to the point that the question they asked themselves was provisions of the hypothetical contract. I can see, my lord, we'd like to see the references. As I say, in the core bundle, 166.
I'm not obliging you to go there. I just wanted to refresh my own memory.
Of course, my lord. So the 64 starts at the bottom of 165. And you can see that it's recorded as having been agreed that in determining the nature of the hypothetical contract, that three-stage test should be applied. And then one sees C.
Yeah.
And then in the upper tribunal, having concluded that the first tier made an error of law in its approach to auto claims, and so omitted material provisions from the hypothetical contract, what the upper tribunal said it was going to do was remake the decision by applying ready-mix concrete. And my lords will see that in core bundle, page 99, paragraph 71. And one sees that from the third line to the fifth. And my lords will also see, and I know that this may be a matter of at least interest to my lords, that paragraph 72 made it clear, the common ground, that when the upper tribunal came to evaluate the third stage, one sees 3 lines up from the end, it should not proceed from a quotes evenly balanced starting point. In other words, it took the Weight Watchers approach. And so, just in answer to my Lord Justice Peter Jackson's question a moment ago, taking perhaps the common ground a stage further, 2 things weren't an issue below at any stage. Either the adoption of the ready-mix concrete structured approach, what I'm calling a structured approach, nor the Weight Watchers prima facie affirmative conclusion approach, I can call it that, once you've got mutuality in the relevant sense and control to a sufficient extent, you have a prima facie affirmative conclusion in favour of employment. Neither of those propositions was an issue. Maybe my lords wish to reconsider them, and of course that's a matter for my lords, but I just wanted to make clear we've come to this point without a dispute about those propositions. And so finally, my lords, bring the matter to the task in hand, what the focus of this appeal is. In my submission, it's about what the upper tribunal did at the third stage of ready-mix concrete. And to distinguish between the 2 grounds in, I hope, short form, what I essentially say about ground 1 is that that's about what I said the Upper Tribunal did by way of displacement of the ready-mix concrete approach with something separate or additional in the form of business on own account, which included and involved not focusing on the terms of the contract in issue. And here we have a hypothetical contract. In other words, it has a kind of life of its own, this business on own account test in the Upper Tribunal's formulation, which operates outside of and independently of the ready-mix concrete approach. And it's that needs to be, in my submission, challenged as an error of law. The second ground proceeds on the disputed premise that I'm wrong, essentially, about ground one, and that business on own account does have a life of its own in the context of the ready-mix concrete third stage. It does something, premises it does something different. And my submission here is that even on that premise, the Upper Tribunal's approach was unsound because it did two things fundamentally wrong as a matter of law. One, it created a presumption based on career history instead of focusing on the terms of a particular engagement or engagements. And secondly, it ignored a number of well-established relevant factors at this stage in the analysis, sometimes described as the economic reality test. I'll come to the cases on that in due course. But the sort of things that that test adumbrates are financial risk, requirement to provide equipment, requirement to provide helpers, those sorts of factors.
So when you say the presumption based on career history, you mean career history not involving these parties?
Yes, my lord. Although there is a very specific point in this case about what was or wasn't done in the first tier about the first of 2 years that had originally been in dispute, which I'll come to explain to my lords. But there were originally 4 tax years in issue in the first-tier tribunal, and in HMRC's submissions for the first-tier tribunal, the opening submissions, HMRC withdrew its objection to the appeal for the first 2 of those years, 2013-14 and subsequent 14-15, but did not do so, I would say, on the basis of a concession that those 2 years should be treated as involving self-employment, simply on the grounds, as it was said, of proportionality.
Well,
so
I think the way that we're likely to approach this is that if Mr. Gordon can show us a concession, then we'll consider the prospect of it being a concession. But I don't think by the same token we're going to assume that it was done on grounds of proportionality. Might be various reasons why you chose not to pursue those 2 years. At the moment, I think we'll leave that empty.
Yes, it's just it was recorded, my lord. It's all I would say. It was recorded in written submissions and noted in the FTT's judgment. But the Upper Tribunal seems to have misunderstood that it was a concession, whereas when one looks at what in fact happened, it wasn't. But my lord, I do appreciate, my lord, we'll want to see the detail of that at the appropriate time.
Just one other matter. Economic reality. Within that, one is entitled or is not entitled to consider the degree of dependence that the worker has upon the particular contract.
The way I would say one is entitled to take it into account, my lord, but the way one should do it, in my submission, is to consider the consequences of the particular contract that's been entered into. So when I say at the third stage that one should focus on the terms, I'm not inviting the court to take some kind of pure contractual interpretation approach. I'm talking about the effect of the terms. So if one compares and contrasts a contract, let's just make it extreme and not use the facts of the present case for the moment, a contract that requires full-time work for a whole year with an exclusivity provision saying no work shall be done for anybody else, at the one extreme, with a succession of short engagements, each of them a separate contract, none of which commits either party to any further work thereafter.
It's within that consideration allows the decision maker to consider the extent to which work was being done elsewhere, where money was being earned in different ways.
Well, it's not so much that, my lord, as the extent of the commitment, if I can put it like that, deriving from the contract. So if one takes, for example, the O'Kelly example, Trust House 40, the casual waiters at the Grosvenor House Hotel, the point is that none of the individual contracts for casual waiting work involved any commitment to do another one or to offer it.
No, but they were all dependent upon it in the end.
But as a matter of happenstance, my lord, rather than as a matter of contractual right or obligation. Whereas if one compares and contrasts a case where there is, let's use the facts of this one, a commitment to do a minimum amount of 160 shows for a minimum fee, then, my lord, from the very beginning of the contract, one can see that there is bound to be at least some economic dependency as a result of the operation of the contract. It's not a mere happenstance, but something that is the product of the terms of the contract itself.
I think what I was trying to get to, and may not be helping, is what is the relevance of the degree of economic dependence of the worker on the counterparty?
It is a factor identified in the Court of Appeal in Hall and Lorimer as relevant. I accept that it's relevant. Indeed, I've submitted as such. My point to my lords is that one has to be careful, however, to distinguish between dependency that just so happens to have occurred, as in O'Kelly, and dependency that is the product of the terms or operation of the particular contract that's been entered into. So it's not, whereas here, one has an advanced commitment to do a certain amount of work, for a certain amount of pay. In O'Kelly, that's wholly lacking. And it just so happens that looking back, there was economic dependency. But that wasn't a feature of any of the contracts that were entered into in the course of the working year. So what I propose, my lords, is now to move on to some legal submissions that underlie both grounds of appeal, if I may, to try and, as it were, establish some of the, I hope, matters that are more straightforward. The first point about the desire for, or the need for, consistency of approach derives from 4 cases. First of all, in the authorities bundle, the case of O'Kelly, which I've mentioned a couple of times by way of instantiation already, my lords will find it in bundle 1.
Do you want to give us the names of the cases before we embark?
Well, the 4 cases are O'Kelly and Trust House 40, Lane and Shire Roofing, James and Greenwich in the Court of Appeal, and Montgomery and Johnson Underwood in the Court of Appeal.
Thank you.
So all Court of Appeal, but James and Montgomery could have been different references. So the first of those, O'Kelly, is bundle 1, tab 7. For electronic reference, the passage is at 180. It's in the report, it's page 115. In the printed bundle, it's 180. And this is an extract from the judgment of Lord Justice Ackner. And I should explain to my lords that his lordship, Lord Justice Ackner, dissented on a point about whether the question of whether a contract of employment was one of law, pure law, or one of mixed law and fact. And so it might be said that some of his comments in this passage were affected by that dissent. But I would say, my lord, that when one looks at it, the call that he makes is not one predicated on his view about whether it's an issue of law. And he says that in the paragraph from C to F, dealing with the submission about too much appellate intervention being a bad thing, he said between C and D, without the appeal tribunal being entitled to intervene where in its view the tribunal has wrongly evaluated the weight of a relevant consideration, it will be open to tribunals to reach differing conclusions so long as they are reasonably maintainable on essentially the same facts. This is clearly highly undesirable, particularly where a substantial number of statutory provisions impose duties on an employer in relation to his employees or confer benefits on employees. And then he deals with other matters in legislation and concludes by saying to permit conflicting decisions on the basis that a broad band exists. A broad band exists, where a tribunal or a court might be said reasonably entitled to decide the issue either way would seem most unsatisfactory. Now, as I say, my lords, I can see it being said against that passage, well, it's all predicated on Lord Justice Ackner saying that it was an issue of law. But one sees the same, as it were, plea.
Was he addressing some particular points that he thought had been wrongly evaluated? I mean, it doesn't, not really. I mean, normally the approach, or at least the modern approach, is that the weight to be attached to considerations is a matter for the decision maker, provided they've had regard to that. The weight is for them. Lord Justice Ackner appears to be taking a different line on that. But it might make more sense if he was addressing a particular factor which he felt had either been overplayed or underplayed in the court or tribunal below in this case. I don't know whether you can help.
I'm sorry not to be able to assist straight away, my lord, but I will endeavour to find the answer to that question. But I do take my lord's point about what his lordship said there about weight of a factor. I accept my lord's point about that. The second case in this run is in the supplementary authorities bundle. It's the case of Lane and Shire Roofing. My lords will find it behind tab 1 of the supplementary bundle at internal page 2. And just to explain for my lords, this was a personal injury case about health and safety at work involving a roofing contractor who fell from a ladder and suffered a brain injury. And the question was whether, in contracting with the company which had itself contracted with the householder.
Sorry, what to say? Where is this case?
So it's in the supplementary bundle of
authorities. It's in the supplementary bundle, sorry. Yes. And
it's behind tab 1, my lord.
Yes.
And it's marked as page 2. And I was just explaining to my lords that it was a personal injury case involving an accident at work. The claimant was working as a roofer in his own name under a contract with a building contractor, which had itself contracted with the householder for some repairs to a roof. And while he was doing that job, he fell off the ladder he was using and hurt himself badly. The question then was the status that Mr. Lane had when doing the work for Shire Roofing. And I'll come back to some of the other parts in this judgment of the Court of Appeal where they are relevant. The passage I wanted to show my lords here is twofold on bundle page 4. You can see at paragraph 12, Lord Justice Henry, who gave the judgment of the court, in the context of safety at work, indicated that there was a real public interest in recognising the employer-employee relationship when it exists, because of the responsibilities that follow. And then at 14, he refers to the authorities. He notes about halfway down, well, he notes 2 points. He says, first, there's a transition, and this is in 1986, between self-employment and employment, towards self-employment. He says, second, there are perceived advantages for both parties if the person doing the work is an independent contractor. And he concludes this paragraph by saying 5 lines up, so even in 1986 there were reasons on both sides to avoid the employee label, but there were and are good policy reasons in the safety at work field to ensure that the law properly categorises between employees and independent contractors. In other words, he's emphasising the importance of having, insofar as one can, a predictable outcome. The third reference, my lords, is also in this supplementary bundle. It's behind tab 2.
But I mean, it's interesting to see in this passage how Lord Justice Henry goes on. Paragraph, well, 15, 16 and 17. I see that 17 has been highlighted. Are you proposing to take us to that?
Yes, of course, my lord. This is on what's been called the economic reality test, or the business on account test.
Back to that.
I do intend to, my
Yes,
lord.
very
That's
well.
convenient.
Yes, sorry.
All I wanted to do was bring
No, I see.
together
Just
the authorities
literally- yes, I see.
on predictability, if I can call it that for short.
Yes.
So the third in the series is also in this bundle, my lord, behind tab 2, James and Greenwich in the Court of Appeal. And just by way of summary, this was a 3-party case involving an agency worker. So there's a contract between the individual and the agency, and a contract between the agency and the client. And the argument for the individual, by the time it got to the Court of Appeal, was about the implication of an unexpressed contract directly between the individual and the client. And there had been some, shall we say, legal debate in previous cases about quite how easy or otherwise it was to imply or infer the existence of a contract in those circumstances. So the particular issue is obviously specific to those factual circumstances. But in the context of the judgment of Lord Justice Mummery, as it was, giving the judgment of the Court of Appeal, you will see at paragraph 7, that's bundle page 11. I don't know whether it's more convenient for me to read it or for my lords to read it. I'll be guided.
Paragraph 7. And before I forget, can I just thank whoever prepared these bundles for achieving a remarkable feat of producing bundles where the electronic and the paper pages are the same. I haven't come across it before.
Well, those behind me should be in receipt of the congratulations.
Paragraph 7.
Paragraph 7, please, my lord.
We'll just look at that.
Thank you.
Yes.
But my lords will see the plea for clear, comprehensible and correct criteria just below C. And so as to achieve consistency necessary for the fair administration of the law, but acknowledging perfect predictability is unattainable. And the last in this series of, shall we say, unconnected judicial references, except that I've drawn them together, is Montgomery, which is in the authorities, the regular authorities bundle number 1, at tab 14. My lord should find that at page 288.
Yes.
And I know my lords have seen this case already, but perhaps not with a focus on this point. This was another agency worker case, similar issues to James and Greenwich. And a passage in the judgment of Mr. Justice Buckley, giving the judgment of the Court of Appeal, paragraph 23, it's bundle page 294. and perhaps just to assist my lords, the passage is just below F, having referred to the specialist employment tribunals regime. His Lordship says, since the concept of the contract of employment remains central to so much legislation, which sets out to adjust the rights of employees and workers, including employees, employers and workers, including employees, it must be desirable that a clear framework or principle is identified and kept in mind. Inevitable that different tribunals will from time to time reach different conclusions on very similar facts, but unless the objectives of clarity and predictability in law are to be abandoned altogether, the principles upon which they base their decisions should be as clear as possible and adhered to. He then goes on to talk about ready-mix concrete, but I'm going to deal with that separately, if I may, because the point about clarity and predictability and consistency doesn't import with it any particular content as to what the rule should be, but it does call for the application of the same principles from one case to the next, whatever they might be. So just continuing, if I may, into the next subject, which is what I will say is the higher court's, in plural, endorsement and approval of the ready-mix concrete approach. One can pick it up with the remainder of this passage. And I should emphasise, my lord, I'm not suggesting that by endorsing the correctness of ready-mix concrete, there is somehow an implicit criticism of Holland Lorimer. Rather, it is about the efficacy of the test, the most useful and most reliable test available in judicial analysis. And essentially, the ready-mix concrete test is one that's been, as it's been put in the authorities, most frequently adopted because it's the most useful. And just to pick up a point that was raised from my lords, in my submission, the ready-mix concrete test doesn't leave out of account anything that is relevant to the determination. It's just a question of how one fits it into the analysis. I'll come back to that. But just picking up with Montgomery, which my lords should, I hope, still have in front of them, on page 294, just between G and H, his lordship says, he regards the quoted passage from ready-mix concrete, and that's the classic passage at 515 of the report, as still the best guide, and as containing the irreducible minimum, I'll come back to that phrase, by way of legal requirement for a contract of employment to exist, permits tribunals appropriate latitude in considering the nature and extent of mutual obligations in respect of the work in question, and the court's control an employer has over the individual. It does not permit those concepts to be dispensed with altogether. And he says, as several recent cases have illustrated, it directs tribunals to consider the whole picture, to see whether a contract of employment emerges. Now, again, I'm going to come back to this metaphor of the whole picture, because it's important to know, as it were, what should be contained in the picture.
Where is the frame?
Quite so, my lord. But he concludes by saying it's important that mutual obligation and control, as summarised, to a sufficient extent, are first identified before looking at the whole. So that's the first reference. There are quite a few, if I may, but if my lords indicate that I can move on, I will move on. But the second one is auto-cleanse. So it's bundle 2 of the authorities, tab 22, and it's page 437. I know my lords have seen this already and will be broadly familiar with the issue involving car valeters said to be, in the contract, self-employed individuals. The point, just in terms of approval of ready-mix concrete as the test, is at paragraph 18 in Lord Clark's judgment, bundle page 444. And my lords will see a reference to Lady Justice Smith in the Court of Appeal, which we can see if we need to directly. The classic description of a contract of employment or contract of service is found in the judgment of Mr. Justice McKenna in ready-mix concrete, and that's the classic passage as ever at 515. Although his lordship goes on to add at 19 3 points which he regarded as uncontentious, including the irreducible minimum point, the effect of a full right of substitution, and what about terms that are not enforced, which we can come back to on the question of control as required. Then in the tax context, ready-mix concrete was applied by the Upper Tribunal in Weight Watchers. That's at tab 23 in bundle 2. My Lords will see the reference in the judgment of Mr. Justice Briggs as he was in paragraph 20.
So can you give a page? I don't have dividers for the tabs.
So you just, your Lordship, just...
Lord Justice Arnold.
So page numbers. Yes, my Lord. So the page number for the head note is 453.
Yeah.
And the page number for the paragraph reference is 460. And really the short reference is His Lordship's describing as the essential tools for identifying an employment relationship being those derived from the 3 conditions set out by Mr. Justice McKenna and ready-mix concrete, and then noting that the Supreme Court had confirmed its authority in autoclaves, which was chronologically proximate. Then moving on to tab 24, which is bundle page 477, we should have the case of Quasi and Stringfellow. That's the case of the lap dancer, or as it put more primly described in the contract, a table-side dancer. The point, however, in the judgment of the Court of Appeal, Lord Justice Elias, is at paragraph 6 and 7, which my Lords will have in the bundle at 479. And so my Lords will see at 6, Lord Justice Elias describing various tests for identifying when a contract of employment exists. And my Lords will see that those include, in shorthand form, the control test, moving along the business integration test, and then thirdly, the business or economic reality test. And if I can just ask my Lords to note, because I'll come back to this, that is treated as synonymous with the question of whether in reality the worker is in business on his or her own account as an entrepreneur. Certainly in Lord Justice Elias's lexicon of the tests. They're treated as the same thing. And then the fourth is the multiple or multifactorial test reflected in Mr. Justice McKenna's judgment in ready-mixed concrete. Brackets involving an analysis of many different features of the relationship. And this is where at 7 one gets the language about most frequently adopted. His Lordship acknowledges that because of the diversity of facts, no one test is necessarily universal. But he says the test most frequently adopted, approved on numerous occasions, and was the focus of the analysis in the case, is ready-mixed concrete. And then at 8, he concludes this part of his analysis by acknowledging that the ready-mixed concrete approach involves that the issue is not simply one of control, and that the nature of the contractual provisions may be inconsistent with the contract being one of service. And applying the test, the Court or Tribunal is required to examine and assess all the relevant factors which make up the employment relationship in order to determine the nature of the contract. One doesn't want to, as it were, overstate the consequences of particular words or phrases in a judgment. But as I understand His Lordship's focus on the employment relationship, is not necessarily confined to the terms, but may include the operation of the terms in practice and the dealings of the parties between themselves, but it is the relationship between the person providing the work and the person doing the work that's important. Then White and Troutbeck is the next reference, my lords. It's in bundle 2, tab 25, page 486. This is the case about the farm caretakers. And the issue in the Employment Appeal Tribunal, as it developed from the Employment Tribunal, was whether there was a sufficient right of control vested in the owners of the property. I'll come back to that point as far as need be, but just on the question of ready-mix concrete, one should see, first of all, on page 489, perhaps a little surprisingly with the benefit of hindsight, at paragraph 24, your lordships will see that counsel for the claimants contended that the tribunal had fundamentally erred in law in applying the ready-mix concrete test, to which his honour judge...
What paragraph are you in?
I'm looking at paragraph 24, my lord, on the left-hand column on page 489. You'll see the submission from of counsel for Mr. White and Ms. Todd, who were the claimants. And you'll see His Honour Judge Richardson's response to that submission at 32, essentially directly opposite on the right-hand column. He says, contrary to that submission, the tribunal was correct to take the ready-mix concrete test as its point of departure, and see its endorsement in Autoclans and Belcher. And then at 34, the learned judge went on to explain, in case it needed explaining perhaps, that he emphasised that the ready-mix concrete test is a multifactorial test. The control test is not the only applicable test. The third element of Mr. Justice McKenna's judgment makes it plain that a wide range of factors may be taken into account in deciding...
So it's all a bit triangular, this, that submission is that it's wrong to apply RMC, should apply a multifactorial test. Answer, right to apply RMC is a multifactorial test.
I take my lord's point. I mean, what ultimately mattered in the case was whether there was a sufficient right of control or not. But the learned judge was, as I read the judgment, seeking to dispel a misconception in the submission that ready-mix concrete somehow left out of account matters of relevance.
It wasn't confined to control.
Quite so.
But is it confined to the terms of the contract?
Well, I say that the focus should be on the relationship between the parties, particularly derived from the terms of the contract, but not necessarily confined to the terms of the contract.
So what else would come into it?
What you might consider the dealings between the same parties.
Before the contract was made?
Quite so, my lord.
So, as it were, I'm focusing on you, but I'm also aware of other things going on in the room. So it's not just the point of focus. There are other matters we'll come to consider how far they can go. But it's been going through my mind when you're talking about the dealings between the parties. In cases of the sort we're concerned with here, whether it was a service contract or a contract for services, the BBC was well aware of Miss Adams before they entered a contractual relationship. And indeed, they entered a contractual relationship because they were well aware of her. And so the career history of the individual isn't relevant to what the parties were contracting about.
Well, my Lord, there is, as I'll come to submit in more detail in due course, a distinction to be drawn between career history, if that means dealings of the individual with any number of third parties, and dealings between the individual and the other contracting party.
Yes, but I'm using the word employer neutrally here.
Yes, of course.
Where the employer is not just hiring an individual to wait at table, for example, but is hiring somebody because of who they are.
Yes.
Surely that must be a relevant feature to understanding the relationship between the parties.
Well, it may shed some light on understanding the terms of the contract as applied in practice, my Lord. But I suggested that it doesn't have, shall we say, an independent life of its own in terms of classifying the relationship that they've entered into.
Not suggesting that it should, but we're concerned here just simply with trying to, as my Lord has put it, to see where the frame is.
Yes.
And I'm wanting to understand whether this is potentially inside the frame or whether your argument is going to be that it's going to be outside the frame.
Well, my Lord, I would suggest that the relevant point of distinction it is, in this context, the classic contractual question, or is it part of the relevant factual matrix? Because if it is, then it is something that can be taken into account in working out what the parameters of the employment relationship were.
So you're not seeking to be doctrinaire about a point of that kind. It'll be a matter to be considered on its merit.
Quite so, my Lord. I mean, I imagine my Lords would be disinclined to take a doctrinaire approach, and I certainly don't invite my Lords to do so. It's a matter of getting to the heart of the relevant issue in the case, and that doesn't involve any preconceived notion about what is and isn't relevant. But some things, I say, are much more relevant than others, and it's important to keep clearly in mind the distinction between something that is at the heart of the decision and something that is at the margins.
Thank
you. And I just wanted to draw to my Lord's attention the reference at the end of 34. I'll come back to what it actually says, but the reference to 516B to 517B of ready-mix concrete is to the 5 example cases that Mr. Justice McKenna addresses in his judgment, along with a comment at the end. I'll come back to that where it matters, but just so my Lords had what His Honour Judge Richardson intended. There are 2 final references in this list. The penultimate one is Krista Ackroyd Media. So it's tab 3 of the physical bundle of authorities, sorry, bundle 3, tab 40, page reference 876. Cases, my Lords, know of in a similar field. I won't put it any further than that for the time being. Nothing special turns on the fact of a television journalist and presenter working for the BBC. The point is at paragraph 11, page 881. Where His Lordship Mr. Justice Mann describes ready-mix concrete as, quote, conventional starting point. And then refers to the classic passage. And then he goes on at paragraph 13 on the next page to acknowledge that cases such as market investigations and Hall and Lorimer have emphasised that employment status should not be determined by rigid rules. But he concludes this paragraph by saying ready-mix concrete formulation remains applicable in assessing whether a contract would be one of service, for services or of service.
Right, and acknowledges the difficulties associated with skilled professional.
Quite so, my Lord. And there's one final reference in this judgment at page 893, paragraph 46, where His Lordship goes a little further in, as it were, endorsement insofar as it was needed for ready-mix concrete. he says at 46 that the full guidance, second line down from McKenna, Mr. Justice McKenna, which continues to represent the correct approach to the issue, is as follows. And he quotes from 515 on the question of control. The final reference is taken from a case which was drawn to your Lordship's attention by my learned friends, for which I'm grateful. It appears in the supplementary authorities bundle at tab 4, page number 35.
I beg your pardon, could you repeat the page again?
Page 35, my Lord, tab 4, insofar as anybody's using a tab. It's the case of varnish in British cycling.
Sorry, what's the case?
Page
PS4.
35, it should be in this bundle, my Lord.
Yes. So what does sorry. No, don't worry. Say tab 4. Yeah.
Tab 4, I'm grateful. It's a case that is an unusual one, although perhaps involving a similar analysis to that which took place in the Court of Appeal in Quasi. The contract wasn't one for the doing of any work at all, but a contract for the provision of training services by British Cycling to Ms. Varnish. I just wanted to deal with the point about the standing of ready-mix concrete. And my Lords will see that at paragraph 33, bundle page 51. And my Lords will see about halfway down this passage, the then President, Mr. Justice Chowdhury, said that G, one of the key authorities on the question of employment, and one which has stood the test of time to a remarkable degree, is ready-mix concrete. And that's obviously an acknowledgement, my Lords, that this is a case now more than 50 years old, but notwithstanding all the developments in the world of employment, it has stood the test of time, and I'll seek to explain to my Lords why I submit that is in a moment. But just finishing with the paragraph. Your Lordships will see that Mr. Justice Chowdhury summarises the three requirements between G and H, and emphasises that the third, just at the bottom of the page, is whether the other provisions of the contract are consistent with its being a contract of service. And then over the page at 34, he acknowledges that the ready-mix concrete approach is not the only test that may be applied, as Quasi makes clear, but it is the one that is most frequently adopted. And that's perhaps because the multifactorial approach that it embodies renders it capable of application to the multitude of factual circumstances that can give rise to a contract of employment. The third limb of the test, under which the Court or Tribunal is required to consider whether the other provisions of the contract are consistent with the contract of service, requires an assessment of the entirety of the contract and the obligations thereunder in order to determine the nature of the contract. And His Lordship acknowledges that no one provision would necessarily be decisive. And that means the Tribunal has to consider and evaluate all of the relevant factors. And then it's not just a question of counting them up. The exercise is very much one of judgment, based on an analysis of the whole picture. And His Lordship then brings in what the Court of Appeal said by way of endorsement of Mr. Justice Mummery, as he was, in Holland Lorimer. So what one can see there, in answer to my Lord Justice Jackson's question earlier, a possible synthesis of the two approaches.
But in that quotation from Hall and Lorimer, Lord Justice Nolan agrees with Mr. Justice Mummery when he said, in order to decide whether a person carries on business on his own account, it's necessary to consider many different aspects of that person's work activity. That suggests you go beyond the terms of the particular contract.
I do see my Lord's point, and when we come to look at the facts of Hall and Lorimer, one might, as it were, gain more insight into what His Lordship is getting at, because
I understand.
Because of the pattern of work.
Yes. But the issue there was We'll come to it, yes.
But I do take my Lord's point about that person, the phrase "that person's work activity,"
Yes.
which appears to go beyond.
Well, then Hall
the
and Lorimer
relationship.
clearly did go beyond the individual contracts.
Yes.
But, as you say, explicable by the facts, but yes.
So what I say, my Lord, just trying, I hope to draw the threads of this part of my submissions together quickly, is that the advantage in juristic terms of ready-mix concrete is that the structured approach that it embodies tends to promote consistency and predictability, while not excluding anything relevant. And I emphasise the relevant because obviously that's perhaps a source of contention from consideration. Whereas the danger, albeit one can guard against it, of a put everything in the mix approach is that it's harder to differentiate what matters from what doesn't.
Presumably you say that in any case, this is such a hallowed test that any court would have to think very carefully before moving away from it.
I would certainly say that, my Lord. I'm sure no court in the current scheme of the state of the authorities would suggest that ready-mix concrete was wrong. It's more a question of how it fits in.
Not at this level, sir.
Well, even the Supreme Court might have a job on its hands, but there we are.
I'm not sure. I agreeing with my Lord at the level of this court, yes, but insofar as the High Court has referred to it, has it not rather been, as it were, in passing, without having to grapple quite so directly with the points that come before us?
Well, it's fair to say, my Lord, that the question of the interrelationship between Hall and Lorimer and ready-mix concrete hasn't been the focus of judicial attention.
No, one can easily see why it might be said, if you didn't have to confront the question, why it looks as if ready-mix concrete has carried the day to a very large degree, but that's different from actually getting down to deciding whether it's right or wrong.
I take my Lord's point. I mean, as a matter of judicial standing, it's we've got shall we say, a stellar lineup of backers, but I accept my Lord's observation that one still needs to consider whether there is something missing from it that is important in the context.
The advantage, I mean, one often sees the fact that as soon as anybody makes a list, however short, it seems to have a magnetic effect, as opposed to simply saying, we'll just have a look at anything that strikes you as relevant. Lists have great potency. And this is a very short list, but it does, as has been said, mean that you don't miss out two very important characteristics of an employment relationship, at least.
Yes, well, they're not merely matters one mustn't miss out, but they're matters that one must find to exist before one goes any further. So they're preconditions. And that's the point I'm going to come to in a moment. Right now, my Lord, this idea of what's been called the irreducible minimum, because it was originally formulated to refer to the concept of work-related mutuality, personal service, and it's become understood as encompassing both of the first two ready-mixed stages. It's perhaps not important how that came about, although I'm sure I could treat you all to an extended dissertation on the use of language in different cases if anybody really were so minded. But let's get on to the substance, which is that it comes from Nethermere, which is in the Original Authorities Bundles, tab 1, at page 288. Sorry, bundle 1, tab 14, at page 288. Apologies, my Lord, I've got that reference wrong. It's bundle 1, tab 8, at page 193. Bundle 1, tab 8, page 193. Nethermere and Gardner. This is the case of the clothing pieceworkers.
Yes.
Very much turned on whether there was a sufficient basis for the employment, the Industrial Tribunal as it was, findings that there were obligations to provide work. But the point in present mind is the question of irreducible minimum, which my lords will find at page 204 in the bundle. So my lords will see at D the famous passage from ready-mix concrete. Then between E and F, a reference to some valuable examples, which we may come back to. And then the emphasis on mutual obligations about an obligation to pay and an obligation to provide personal service, his own work and skill. And he goes on to say, there must, in my judgment, be an irreducible minimum of obligation on each side to create a contract of service. I doubt if it can be reduced any lower than in the sentences I have just quoted. Now, in that instantiation, it looks as though His Lordship, Lord Justice Stevenson, was directing attention to the first stage of ready-mix concrete, because he talks about an irreducible minimum of obligation. At any rate, my lords, without taking too much time over perhaps a point of only academic interest, by the time of Montgomery, which was the reference I was going to take my lords to, it's bundle page 288, tab 14. My lords will see at page 293, paragraphs 20 and 21, really, the, as it were, the punchline is at 21. That His Lordship there concludes that the passage that was being endorsed by Lord Irvine in Carmichael when endorsing Nethermere was both the concept of mutuality of obligation in the relevant sense and the concept of control. And he says at 22 that there's no doubt that Lord Irvine was approving that passage, and I'm easily persuaded we should follow it. So that's the passage in Nethermere about the irreducible minimum. And so what emerges clearly from Montgomery is this point of principle. And we'll see it, but perhaps it's most easily seen at 24 in the judgment. So it's just over the page at the top of 295. It's an error of law if a tribunal reduces the two basic and essential facts, i.e. mutuality of work-related obligation, personal service on the one hand, and sufficiency of control, right of control on the other, to no more than material for the melting pot, and thus find a contract of employment when one or both were absent. If that happened, says His Lordship, the tribunal misdirected itself in law.
Could I just situate this in your presentation? The legal submission started with consistency of approach, then you went to endorsement of RMC. Is this part of this, or is this irreducible minimum another point?
So irreducible minimum is another point, and I'm sorry for not making clear that it's a demarcation.
Might this be your third point, the nature of the RMC?
Quite. So what is the irreducible minimum, and what is it about?
Thank you.
I'm sorry, my lord, for not making that clearer earlier. So the point is, first two criteria in ready-mix concrete are preconditions and not merely elements for finding a contract of employment. And one sees at 28 in Mr. Justice Buckley's judgment the point spelled out in more detail, page 296. There's a reference to McMeechan, which is the case about the individual who was claiming a payment from the Secretary of State based on the insolvency of the work provider. And His Lordship notes, it seems that the tribunal here had understood Lord Justice Waite's judgment in that case, perhaps correctly, as indicating that the task in hand is to weigh up all the factors and reach a conclusion without reminding itself that Mr. Justice McKenna's first two criteria must be met as an irreducible minimum. And then he goes on at G to say, it follows that if he, that's Lord Justice Waite in McMeechan, did intend to reduce the criterion of mutual obligation and by inference control as well, to no more than matters to be weighed up with all other factors, with great respect he disagrees. More to the point, I consider such an approach to be contrary to ready-mix concrete, but also to Nethermere and Carmichael. And then moving
as far
on.
as this point is concerned, in this case, this is not an issue. Is it? It's not an issue that the first two, that stages 1 and 2 in ready-mix concrete must be satisfied. And, they're not matters that go into the mix of stage 3.
My Lord is correct.
Yes.
The reason I'm paying attention to this, my Lord, is with a view to making this submission that these first two factors carry potency.
But they're essential.
They are essential, my Lord, but they do not lead to, shall we say, a low-grade conclusion easily displaced. They are important in the context of the decision-making process.
Yes, but I think that what that will lead on to, and you're probably going to come to this, or maybe you are, is what does control mean? Because there are some cases where control is at a very high level. It's easy to see this control. But there are other cases, of which this may be one, where the question of control is itself not an easy question. So to say, oh, well, on balance there is control, therefore the potent factor is established, is perhaps giving that factor more weight than in a particular case it may deserve. Yes, it has to be there, yes there is, but if you compare someone working 9 to 5 in a factory with what Miss Adams did in this case, I mean, they're miles apart, aren't they, in terms of the putative employer's control. But to equate them and give them similar weight, just because you've concluded there is control, may be a bit oversimple, perhaps.
Well, I do understand my Lord's observation. I would say embedded in the concept is a sufficient right of control.
I mean, that's such a slippery concept too, isn't it?
Yes, my Lord, but what it imports is that you have concluded that it is sufficient to make one, in the old-fashioned language, the master.
Yes.
And so it's that point of sufficiency that matters.
Yes. Yes.
And I do take my Lord's point that control takes very many different forms, and that the factory worker and the surgeon, or the and so on, you find it operating in different ways in different cases. But it's nonetheless, as it was put, I think, rather colloquially in one of Mr. Justice Langstaff's judgments, I don't think your lordships have it, who is the boss? Is there a boss?
Yes.
But it's about identifying that. And so I do take my Lord's point that in some cases, some conclusions about control or arguments about control are going to be very different. But if one has ultimately decided that there is a sufficient right of control in the relevant sense, that's the potency that carries through towards the conclusion of contract of employment. It's not the end of the exercise, but I say that it has some real force.
But the point that I think may lie behind my Lord's question is this, that if you have to be satisfied that there is a sufficient element of control, take control as the example here, of the precondition, you have to be satisfied of that. But let's suppose you are just satisfied, as these cases throw up. That may have a different resonance when you come to consider the ultimate question, than if you had been abundantly satisfied that there was control. Are you contesting that? Are you seeking to say that once the on-off switch of control has been decided, that as soon as it's on, you forget control, regardless of whether it was blindingly obvious that there was control or whether you were just satisfied?
In my submission, my lord, it's not so much a question of a switch, but I would use the metaphor of being satisfied that the requisite element is present. And once you're satisfied that the requisite element is present, one doesn't go on to measure it.
Right.
As to extent.
Use the concept of a hurdle. You're seeking to persuade us that it's of no relevance at all to the ultimate decision how, with what ease or difficulty, one crosses that hurdle.
Well, what I suggest is this, my lord, that when one starts to compare different types of control or different forms of control, one is liable to end up in something of a metaphysical debate about what kind of control is more potent than another kind of control. And it may be extremely difficult to measure one case against another. It may be said, taking my Lord Sir David Richards' example, the factory worker is very heavily controlled, one might say, but that may just really be a feature of the routine aspect of the work. In the moment of performance of operating the particular stage in the production line, it may not be possible to control what that individual does any more than anyone else.
Let's not go outside the studio. Take a case to be contrasted with this one, where instead of having a highly autonomous, experienced professional leading a program and having, in a sense, her own brand, one had perhaps a junior person who was at the microphone, fine, but was had the producer breathing down his neck, was being told exactly who the next guest was going to be, was told exactly what the content of the program was going to be, because they were at a different stage in their career and didn't yet have the standing of the respondent in this case. Now, are you saying that that difference would not be relevant to a tribunal decision or a revenue decision?
Well, I would say, my lord, taken in the form of is there more control in the one case than in the other, it is irrelevant. So that would be my submission, my lord, that put in the form of the question, yes, is there more control, yes, in the case of the junior presenter than the senior presenter, yes, that it's an irrelevant matter. Right. Okay. But what
I just wanted, I didn't want to, as it were, argue the point with you. I just, yes, wanted to understand what your submission is.
Quite so, my lord. But I would add this nuance, that difference in standing is likely to be reflected in other provisions of the contract or the relationship, and that one will find the point manifesting itself appropriately at the third stage, so that the degree of autonomy that the more senior presenter has by comparison with the more junior, in my lord's example, is more than likely to find form in some other aspect of the relationship. But it's not a matter of measuring out one type or extent of control against another.
So as far as your submission is concerned, mutuality, yes, no. If it's yes, on you go. Control, yes, no. If it's yes, on you go. And you don't return to those issues again.
In my submission, once the court's satisfied of those issues, it's satisfied of them and moves on.
Okay.
But if I may, my lord, the way in which the parties operate their dealings in practice may be relevant at the third stage, both in the employment context and the tax context, slightly differently in the tax context of Section 49 of ITPA, because the court is enjoined to have regard to all the circumstances, including, implicitly not limited to, the terms of the contracts. And so the way in which the parties deal with each other in practice may, and I can't put it any higher than that for the moment in terms of a general point, may be relevant in that way. And it may be relevant in an employment tribunal, both in focusing on what the terms of the agreement were in the first place, and in analysing the third stage of the employment relationship. Just to finish the point on Montgomery and the Court of Appeal's criticism of the Employment Appeal Tribunal, I should emphasise for my lords that unusually there was a majority decision comprising the non-legal members, with the legal member, Mr. Justice Charles, in the minority. So the criticism at 34 of Mr. Justice Buckley's judgment was taken from that non-legal majority decision, quoting, "Guidance given by the authorities is to consider all the pros and cons of whether there was a contract of service." And then he says at the top of the next page, "In other words, they, the EAT majority, endorsed the tribunal's approach, which for the reasons I have given, I believe was wrong in law." So taking an all the pros and cons approach so as to exclude mutuality and control is wrong in law. But can I just interpose here, my lords, a submission about the concept of the minimum in the irreducible minimum? Because in my submission, one shouldn't be misled, although some tribunals have been, by that language, particularly tribunals operating in the tax field, not familiar perhaps with employment issues. That in my submission, it doesn't in this context mean something that is low. It's more like, to use the metaphor of a minimum entry requirement for medicine at university. I appreciate that where one pitches the level is a matter of debate. But what I mean to suggest is, my lords, that the entry-level requirement comprising mutuality of obligation and control is already a considerable distance along the journey towards the conclusion of a contract of employment. I appreciate that one mustn't then leave out of account the third stage, but it is important to understand what in this context that word minimum is doing, because the conclusions about work-related mutuality and control have their own cogency.
You say it's essential.
Well, the
Irreducible minimum just means essential, is that what you're
quite similar. Essential, and I would add, but I appreciate this is a submission, important. Essential because important. And just to give my lord some instances, albeit these are by no means comprehensive, the first stage, mutuality in the relevant sense, will exclude cases that are not sufficiently related to the provision of work for pay. So examples in my lord's bundle are quasi, the dancer, varnish, the cyclist, or cases with what have been described as full rights of substitution. It's not a case in my lord's bundle, but it's referred to in a number of other authorities, a case called Tanton in Express and Echo newspapers, where the delivery driver had an unfettered right of substitution to send somebody along to do the work in his place, and indeed to make a profit on any difference between what he got paid and what the substitute was paid. The second stage will exclude cases where there is no sufficient power of control, and an example of that, which my lords have, at least because of me, had to pay attention, is Montgomery, which we've just seen. Montgomery is an example where there is no sufficient power of control as between the claimant and the agency. So, my lords, what I propose to do now is to move on to the third, what I have in my notes is the third topic of general relevance. So we've had the higher court's approval and endorsement of ready-mix concrete. Secondly, what's meant by the irreducible minimum. And the third topic I'm going to address, my lords, about is what does business on own account mean? I'm just going to deal with this very generally for the moment, my lords, because obviously it quickly segues into contentious territory. The phrase has been used in different ways in different cases. Sometimes it's just used as a synonym for self-employment or independent contractor. So a person in business on her own account is somebody who is self-employed. And so it's simply a statement in that context of the conclusion. It doesn't carry any meaning. It's just another way of putting the same point. Secondly, sometimes it's used as a shorthand for the third stage of ready-mix concrete. But as I'm going to come on to explain, the focus of that third stage and the focus of at least what Hall and Lorimer regarded as business on own account is different. It's not coterminous. And thirdly, and in my submission, my lord, this is the first time this has occurred in any of the authorities, in this case, the phrase is used to carry with it a substantive content. So as, in my submission, what the Upper Tribunal did here, and I appreciate this is very much contentious, a status on the person in question, Ms. Adams, in the hypothetical contract, that status being one of being in business on one's own account, which it was then said one had to displace by demonstrating a sufficiently, by demonstrating a sufficiently different nature or extent of work from that which had gone before. As I'll come on to submit in due course, my lords, and my submission, that novel approach of the Upper Tribunal is the core of where it went wrong. And I'm going now to move on to the two grants of appeal.
But sorry to interrupt here, but
Not at all.
I'm sure we'll be coming to this. But I mean, carrying on business on your own account as a synonym for self-employed, there may be cases, and I think this is one, where the putative taxpayer is unquestionably carrying on business on her own account. The question is whether this particular contract falls within that. So I'm not sure that fits within any of your three categories. So, I mean, there is no dispute, is there, in this case, that both before and concurrently with Ms. Adams' performance of the contract with BBC Scotland, she was, quote, carrying on business on her own account, and she was doing other engagements, which, I mean, I have assumed, but tell me if I'm wrong, she was chargeable to tax under Schedule D.
My lord is right about that.
Yes, so clearly she was in business on her own account, carrying on her profession, if you like. I'm conscious of Lord Justice Nolan's concern about that. But so the focus on this is, well, given that fact, how does that play so far as this contract is concerned?
Well,
And that actually, in a way, was Hall, maybe not quite, but maybe that's not quite Hall and Lorimer, because I think the revenue's contention in that case was that each and every contract was a contract of employment, albeit many of them lasted only a day.
yes, it's a different fact pattern.
That's a different point.
It's more like Fall and Hitchin, to which I'm going to come in a moment. my lord.
More like, although in Fall and Hitchin, the dancer had not actually done any work on his own account.
Well, had in the past, but not in the year in question.
Tried.
Yes, all right. He was at the start of his career, I think, and was grateful to get some work from Sadler as well.
Yes, I take my lord's point. I mean, this case is about simultaneous work in the form, as I would submit, of an employee and self-employment, which is quite possible. It's perfectly possible.
Yes,
It all depends on the facts.
Absolutely.
Don't you have to tease out, when you say carrying on business on own account, is it this business on own account, or is it at the same time carrying on other business on own account?
Yes.
I mean, it's not, well, I can't just say business on own account without looking at deciding whether you're talking about this business or general
Well, I suppose it depends on how widely one defines the business in question.
Well, I think the way I was approaching it was that it's agreed, I think, that Miss Adams was doing other work on her own account.
Well, the way I prefer,
This was part of that, or whether it was a contract of employment.
well, the way I prefer to put it, my lord, is that Ms. Adams was plainly carrying on through Atholl House work which was properly treated for tax purposes as self-employment work.
Yes, exactly.
So, for example, there's no issue about, let's say, the contract that Ms. Adams entered into for the provision of her services to appear on Loose Women.
Yes.
That's not in play in this case, and as a matter of principle, it wouldn't be.
But in a sense, that's an important distinction. No, I'm putting that too strongly. It is a potential distinction between the facts of this case and the facts of our other case. So, in Mr. Hawksby's case, yes, he did other work, but he did it in a different capacity. So, the contracts at issue concerned his capacity as a presenter, whereas his other work was as a writer. So one could make a distinction, whether it's relevant or not is another matter. One can distinguish between work done in the same capacity, as with Ms. Adams, 2 roles as presenter, and someone who is engaged in different capacities.
Well, I can see the point, my lord. It's a question of how carefully one distinguishes. So one could say that work as a writer is different from work as a radio presenter, or one might say, and I imagine it will be said by my learned friend, well, that's all work as a journalist, albeit expressed in different forms.
And in this case, Miss Adams does other work, for example, as a speaker, not to do with broadcasting, but to do with just taking a public role
Quite so.
on issues.
Quite so. One might say that's a different kind of work, but the danger, I would say, my lord, of an approach to the third stage which seeks to compare and contrast different types of work is that one gets into, shall we say, irresolvable distinctions about whether something is really different in kind in one form of work
Particularly if you
from
wouldn't
another.
get one sort of work if you didn't do the other.
Well, it might be that a profile leads from one thing to another, my lord, but it's not necessarily very easy to disentangle one work stream from another work stream. But the danger, I would say, cutting to the chase for a moment, of the Upper Tribunal's approach here of asking whether the work for the BBC was sufficiently different from the other work, is to lead one into a morass of questions that don't permit of anything like straightforward answers. I would make 2 further observations, if I may, both in response to all the questions that have just been asked. I would say, in response to my Lord Justice Arnold's point, a person might be both employed and self-employed for 2 different engagers at the same time in the same capacity. So one might enter into a contract of employment for presenting, and a separate contract, which is properly regarded as one of self-employment for presenting. It all depends on the terms of the particular contracts and the relationship between the different individuals. And in answer to my Lord Sir David Richards' question, I appreciate that different perspectives are possible, but I would ask my Lord to bear in mind this submission, that I would say one ought to start with the contract in question. Not necessarily end there, but start there and ask oneself whether its terms or the relationship which it comprises is consistent or inconsistent with a contract of employment, assuming one's made the first and second
You made a
stages.
submission earlier, which at first blush seems to have some force to it. Namely, you look at it as at day 1 of the contract, because after all, you ought to be able to say, is this person an employee or not an employee on day 1?
Yeah, quite so, my lord. And I would add to that, if one starts, and in my submission, this is the flaw essentially put in the Upper Tribunal's approach. If one starts from the question of asking, was this contract entered into as part of a business on own account, one is liable, as happened here, to fail to pay attention to the terms of the contract, which are indicative of employment.
Yes, I see that. I mean, that's your ground too, isn't it, really?
Quite so, my lord.
The other thing that's to be borne in mind is that in these discussions where we're talking about somebody who has more than one string to their bow, the employment that one's going to be talking about may very well be part-time employment, but that doesn't prevent it from being employment.
Quite so. You may have a substantial number of part-time employments. They may all be employments, or some of them only may be employments and others may not be.
Right, so there's a danger in saying, well, so-and-so was 98%, so-and-so else was 70%, and so-and-so else was 90% of their time. That may be a relevant factor, it would seem to me, because it tells you something else about economic dependency. But it's not to be assumed that somebody can't be on a 50% contract. And
yes, I mean,
indeed, many people will, for good reason, work part-time because of other commitments.
Well, yes, my lord, I mean, putting the matter in two different ways. I mean, a person may only want to work half the time. And so...
And their other commitments may have nothing to do with their career. It may be to do because of their family commitments or something like that.
Quite so, my lord. And in another case, at the other extreme, one might find a person who is very highly remunerated for only a small amount of time commitment. And so the question of dependency might be completely adventitious in a way. That person might just have chosen to enter into that lucrative arrangement.
All of these positions all these matters will take their proper position in the analysis of the individual case.
Yes, I would accept that, my lord, and that's as it should be in my submission. So what I say by way of summary in relation to the first ground of appeal, and just for my lord's note, I'm not expecting my lord to turn it up, this is paragraph 17 to 32 of our skeleton argument, pages 21 to 25 of the core bundle. There are three errors here in the Upper Tribunal's reasoning. The first is what they have done in my submission is to use business on own account as what I'll call a displacement test for the ready-mix concrete third stage. In other words, instead of doing the exercise that stage calls for, they've applied business on own account instead.
A substitute.
As a, what, so, my lord? But one has to be a little bit careful with the word substitute in this context. But as, that's why I was trying to find a different word, but I'm perfectly content with substitute, provided one doesn't get mixed up.
Different test.
Yes, but it's more than different because it clears the field of the ready-mix concrete third stage analysis of the terms of the contract. Secondly, it undervalued the strength of the prima facie conclusion derived from satisfaction of the first and second stages. And thirdly, it perhaps as a result of point one, lacked any relevant focus on the terms of the hypothetical contracts in our particular context. There may be some debate about whether the terms of the contract or the hypothetical contract should be the complete focus of attention. But in my submission, one certainly can't ignore them completely, which appears to have what the Upper Tribunal did here. What I want to move on to, my lords, now is to deal with some analysis of the nature of the exercise, the analytical exercise at the third stage of ready-mix concrete. I know you, my lords, have had some submissions on this topic already, and I'll be as brief as the subject permits. The first reference I wanted to show, my lord, was Weight Watchers. It's in Authorities Bundle 2, tab 23.
So, sorry, the heading here, what's the proposition?
The nature of the exercise at the third stage of ready-mix concrete. To analyse what's going on, if I can put it like that colloquially, my lord.
Yes.
And the starting point for these submissions was to be Weight Watchers, which is bundle 2, tab 23, page 465. Is the sorry? That's the relevant passage in the judgment I'm going to come to. The head note is at 453. And as my Lord know, this was a two-party case, if you like, albeit with HMRC intervening. What was the employment status of the leaders, the relationship as between them and Weight Watchers? There's no IR35 issue or anything like that. And the relevant passage of Mr. Justice Briggs's judgment starts at paragraph 38, at page 464, under the heading Control. And just to summarise for my lords, there had been a decision of the High Court of Australia in a case called Narich about the relationship between Australian leaders and Weight Watchers in Australia. And so there was some considerable argument about how far one could take those findings for the purposes of the particular issue before the First-tier Tribunal. Well, they'd been very careful to avoid being sucked into the trap of just applying it. And in this context, there was an issue about what was the degree of control that Weight Watchers had over the leaders. And one sees the submission at paragraph 40 at the foot of page 464. Because the tribunal put too much reliance on, sorry, it was the Privy Council, I'm sorry, not the High Court of Australia, in Narich. Because they put too much reliance on it, they'd failed to have proper regard to the control test. And also then, he said at the bottom of the page, the FTT was thereby led into a failure properly to conduct the third test, namely, whether having regard to all the contract's terms, the contract was truly one of employment. And so his lordship was there addressing, as he said at the end of 40, the question as one of legal principle, before he got into the detail. And as his lordship puts it in 41, he saw no real tension, let alone incompatibility, between ready-mix concrete on the one hand and Narich and Stevenson on the other. His lordship referred to the fact that Mr. Justice McKenna described the third condition as a negative condition, and that's the we'll see the reference in the judgment if we need to, and then put it in terms of, are the other provisions of the contract consistent with its being a contract of service? And so synthesising those two references, Mr. Justice Briggs says, those two parts mean that the substance of the third condition is that the terms of the contract taken as a whole should not be inconsistent with it being a contract of service. My lords, I emphasise, I don't seek to make any point on the language of consistency or inconsistency. It's a question of substance. Focusing on the terms of the contract taken as a whole, what do they tell you about whether or not the contract is one of employment or not one of employment? And you can use whatever word you like, but consistency or inconsistency does the trick, put in different ways. And what one sees from this passage going on to 42, I'm going to come back to the references to the examples from ready-mix concrete in just a moment. But you'll see his lordship says at the end of 41 that the first, second and fifth examples in ready-mix fortify, last words of the paragraph, fortify that conclusion. In other words, the conclusion about what the test comprises. And then at 42, I know my lords have seen this already, about the prima facie conclusion that it's a contract of employment. Unless viewed as a whole, there is something about its terms which places it in some different category and not starting from an evenly balanced starting point. Really here with the acknowledgement that I'm repeating myself, what his lordship is here getting at in my submission is the cogency of the conclusion that one arrives at, albeit not a final conclusion, only a provisional one, from having been satisfied on mutuality of work-related obligation, bringing with it an obligation of personal service first, and secondly, a sufficient power of control. That is already very much like contract of employment, albeit there may be indications in the terms that that's not what it should be. And if I can just carry through what His Lordship was getting at in terms of the examples from ready mixed concrete, I'm sure my Lord...
I would just stay with 42 for the moment.
Yes, of course, my Lord.
The second last line of that paragraph refers to a prima facie affirmative conclusion. I think that's... it suggests that one is bound to, after having gone through the first two stages, have reached a prima facie affirmative conclusion. I think what lies behind some of the questioning, both today and last week, is to do with the fact that one might have reached a conclusion that this was a contract. In other words, there was enough mutuality for it to be a contract. And one might have come to the conclusion that there was just about enough control to satisfy the second stage. But that one was very far from having reached any conclusion of any kind beyond those two matters in a particular case. Now, in that situation, does it make sense to speak of a prima facie affirmative conclusion? Well, actually, one's conclusion might be, well, all right, there's enough for one, there's enough for two, but actually I'm going to have to look at the wider picture to form any conclusion at all.
I'll make two observations, if I may, my Lord. The first is that the first stage isn't just, and this is obviously a problem that's bedeviled the cases over many years. The first stage is not mutuality of obligation merely in the sense of, is there enough to have a contract? It must be the right kind of mutuality in the sense of to place the contract, metaphorically speaking, in the employment field.
Yes.
In other words, it must be obligations in respect of work. And either the provision of work or payment for it, first of all. And second of all, there must be an obligation of personal service. In other words, the individual must be obliged to do the work herself. It can't be, if there's an unlimited or essentially unlimited right of substitution.
Would it not be right that if there was a contract just for one piece of work that was plainly a contract of services, that there would nevertheless be mutuality of obligation within that at a very weak level?
When the work is being done,
yes,
you would say there was a mutuality of work-related obligation.
Yes, so that, I mean, in a sense, in that very extreme example, that doesn't get you very far, just to tick the first box.
I accept that, my Lord, and what has been said in a number of other cases, although I'm not sure my Lords have had to pay attention to them, for example, the case of Window, the Secretary of State for Justice, is that the lack of any obligation to offer any more work or to do any more work may colour the court's approach to the question of the overall relationship between the parties. But you see, my Lord, there might be no real controversy about the instance that my Lord identifies about, let's say, a one-day job. It might be no problem to say that's a contract of service. The question is why it would matter. And usually in that context of short, discontinuous employment, where it begins to matter is whether the individual has sufficient continuity of service to acquire a statutory right, such as the right not to be unfairly dismissed. And so what one sees in many of the cases is that debate. Or, for example, some of the cases are about a statement of employment particulars. One is only entitled to that under what's now Section 1 of the Employment Rights Act. If one's an employee, if one is an employee, one is entitled to that statement relatively soon after commencing employment. But my point, my Lord, is that where one has a series of short and discontinuous engagements, the battle is likely to be, in the employment context, whether there is some overarching relationship that can be characterised as a contract of employment, or whether I don't want to get too bogged down in technicalities of employment law, but there are special provisions of the Employment Rights Act which can deem continuity, even though work hasn't in fact been done. But my Lord, the answer to my Lord's point is that it's a matter of pure analysis. A one-day contract for work to be done by a particular individual may very well be a contract of employment. It probably is. And I'm not sure that there is any disconcertion that should arise from that conclusion. In other words, that may very well lead to the conclusion that so far as any employment rights are concerned, or any question of vicarious liability or liability for health and safety at work, an individual should be treated as an employee. It doesn't matter that there isn't some lengthier engagement between the parties thereafter. Obviously, in the present case, my Lord, we're talking about the question of taxation of income under a particular contract. But it one shouldn't lose one's focus, if I may, my Lord, on the way in which the tests can be applied in a wide variety of different circumstances.
But I think this exchange started with my Lord asking whether it's appropriate to talk about a prima facie affirmative conclusion in circumstances where stages 1 and 2 have been satisfied, but not, as it were, in spades. I mean, yes, you've ticked the first box because there's an obligation on the individual to do some work and an obligation on the person engaging him to pay him for the work. And he's got to do it himself. She's got to do it themselves. So stage 1 is satisfied. Stage 2 is an agonizing process of deciding whether there is sufficient control to be consistent with a contract of employment. On balance, yes. But why does that lead to a prima facie affirmative conclusion, I think was my Lord's question.
My answer, although it may not be one that's accepted, but my answer to the question is that the quality, the nature of those conclusions is in and of itself important. Because these are essential and important elements in identifying the existence of a contract of employment.
Well, that I do.
And they're of a different order as a matter of analysis from a question such as whether the contract provides for holiday pay, to take an example. In other words...
the approach might be, stage 1 is a very, very minimal. The point of stage 1 is simply to say, are we in the field where it's even sensible to ask the question, is this a contract of employment? That's all stage 1 is doing. Well, not doing much more than that. Because all is required is, there is the personal service, I've given you that point, but A, personally will do something in exchange for payment, and that's stage 1. Stage 2 goes rather more, I think, to the substance as to whether there's a contract of employment. But it might be stages 1 and 2 are sufficient to constitute a contract of employment, provided that the other provisions of the contract point to that conclusion. So 1 and 2, as indeed Mr. Justice McKenna said, are necessary but not always sufficient.
I'd accept that way of putting it, my Lord, entirely.
I think we're just, perhaps my Lord and I are focusing slightly on Mr. Justice Briggs's use of the prima facie affirmative conclusion.
I don't think His Lordship meant to express any, as it were, substantive test in that use of language. What I suggest His Lordship had in mind was the force of the conclusion. It's important to remember the facts of the Weight Watchers case.
Well, what he's doing, as he says himself, is putting it more broadly. And I think we established last week, but you'll tell us if we are wrong, that this putting it more broadly doesn't have an ancestor in any of the cases. That this is Miss Justice Briggs' initiative in this matter. And if I'm concerned about 42, I'm probably more concerned about 111, which is where you're likely to be taking us.
Well, I can deal with that point without being taken to 111 or taking my Lords back there, but if my Lords want to see it, of course. But I would...
Well, because basically at 111, we find that he's saying, well, really, if you've got 1 and 2, unless something crops up that makes you want to look at 3, you don't even really have to go into a detailed analysis.
Well, what I wanted to explain to my lord a moment ago, and I'll explain now in the context of this paragraph, is it was very much rooted in the arguments and the facts of the case itself.
Well, exactly. So that's why we have to consider whether it really is a useful accretion to what was said in the RMC.
Yes. I follow my lord. I mean, as I said, it was never an issue, as it were, as between the parties to this appeal. I appreciate my lord is, and this court is properly interested in the question. The submission I would make in the context of the factual issues in Weight Watchers is that what was being said there was, well, the tribunal hadn't paid enough attention in its judgment to all the other terms said to be inconsistent with the conclusion of employment. But the arguments were, if I can put it like this, of a low order of quality. And you get a flavour of it later on that same page. For example, at 114, I'm just picking that one, there's another example at 113. The example at 114 is, well, the leaders might have spent a bit of money on buying cooking ingredients, and there might not be very many members turning up to that particular meeting, and so they might make a loss. That was the proposition.
Yes, I'm sorry, I hadn't noticed until we got to 114 that you were involved in this yourself.
Against Mr. Peter.
Against Mr.
Quite so, quite so. So familiar faces all round.
Yes.
But the point was, first of all, as it were, largely theoretical and not practical. And the second answer to it was that it wouldn't have been the product of the contract anyway. In other words, the leaders weren't obliged to buy materials to put on a cookery demonstration. And so if they happened to have done so, they were doing so of their own initiative, not as the product of the terms of the contract. And so one gets a sense of why Mr. Justice Briggs would have had, as it were, judicial sympathy for the First-tier Tribunal in not running through in a kind of checklist approach every of the 30 points in the closing note on this subject that was submitted, and of course the 30 counterpoints that I was obliged to submit in response. The tribunal felt it unnecessary to delve into those matters, because it regarded them globally as not providing any feature inconsistent with the contract of employment.
Well, that has helpfully situated these words within the context in which they were spoken. But where does that leave you in seeking to maintain them as being an overall validity?
Well, what my lords, where it leaves me is what I'm going to do is show my lords what drove these comments in the first place from Ready Mix Concrete itself, and then show my lords 3 other places where the same approach has been adopted or something very similar to it. I accept my lord's point that there isn't a predecessor decision to Mr. Justice Briggs and Weight Watchers which says something similar, but there are some successor decisions which say something similar.
Well, say something similar after argument, or just repeat?
That's a very good question, if I may say so.
Well,
I'll deal with that question as I go through the other references. So I was going to take my lords back to Ready Mix Concrete itself, which my lords have in the first authorities bundle. At tab 3, the classic passage is page 97. I'm just going to focus on the passage at 516, bundle page 98. And what his lordship there referred to as the third and negative condition, and his 5 examples to explain what he meant by provisions inconsistent with the nature of a contract of service. And it was the apologise, my lord, I'm just going to pick this up. Let me make sure I've got this correct. Is the first, second and fifth of the examples, which Mr. Justice Briggs found helpful on this point. And so the first example is the contract to produce a thing or a result for a price, not a contract to serve another for a wage. And so one sees in particular, my lords, that although the builder is obliged to do the work himself and to accept a high degree of control, the nature of the contract treated as a whole is to produce the building. And so properly regarded, it's a building contract, not a contract of employment. The second example is a contract of carriage, which is ultimately the conclusion on the facts. And you can see that it's, although the individual carrier may be obliged to drive the vehicle himself and to accept the other's control over his performance, it's still a contract of carriage because, taken as a whole, what it's about is an obligation to carry somebody else's goods. Perhaps just another iteration, in a way, of the first example, albeit it involves a service rather than the production of an outcome. And the fifth example is rather different. It's essentially a two-part contract. It's certainly not an example I can say I've ever come across in practice, but one is to do work and the other also to sell some land. And essentially they're severable, says Mr. Justice McKenna. It's one document with two separate contracts within it. But the point of these three examples, my lord, is to cast light on what Mr. Justice Briggs had in mind in terms of his analysis of Mr. Justice McKenna's third stage. In other words,
Can I ask you about that? Because at the moment, it seems to me that the language used by Mr. Justice McKenna at B, negative condition and provisions inconsistent with the nature of contract of service, are supportive of Mr. Justice Briggs's analysis in terms of the structure of the test. If you get over hurdles 1 and 2, then absent anything else, you're going to conclude that it's a contract of employment. But more importantly, from my perspective, what the examples show you is that you can clear hurdles 1 and 2 very substantially and yet still fail to show employment. Because even though there's a lot of mutuality of obligation and a lot of control, other provisions of the contract might show you that it's nevertheless something different.
That's perfectly fair, my lord. But I'm not sure that Mr. Justice Briggs meant at any stage to downplay the importance of the third stage. It was just on the facts of Weight Watchers. It was a morass of poor quality points. In other cases, they may be very important. The question is, do they change the character, the nature of the contract, from what looks like a contract of service after stages 1 and 2, but may in fact be something else? I appreciate the examples that Mr. Justice McKenna gives, as it were, by way of counterpoint to a contract of service, are contracts for services of a particular kind, the building in the one, carriage in another.
One notes that this list begins with him noting that in the context of that case, the third and negative condition was, for his purposes, the important one.
Quite so, because he uses it to conclude
Yes.
that taken as a whole, the relevant contract is one of carriage.
I think a lot of this debate is it may be no more than semantic. I don't know in the end, but a lot of this debate is about whether, by describing something as a negative condition, one is, as it were, somehow relegating it. But one sees in this case that he considered that it was the important condition. And I think what lies behind my questions is to leave open that possibility in cases where it is the important
Yes, it
analysis.
may very well be the important point in the analysis, my lord. On the facts of Weight Watchers, it just wasn't. Once you had the prima facie affirmative conclusion, as his lordship put it, from mutuality and control on the facts of that case,
Yes,
there was really nothing much else to weigh against it when one got to the third stage. And he was thereby, in the section my lord was concerned about at 111, addressing the submission that was being made by counsel for Weight Watchers, that the tribunal had gone wrong because it hadn't gone through all the points.
I understand that. It just seems to me that at the moment that the fact that it applies differently in another case doesn't mean that one changes the test.
I'm not suggesting that...
Or one starts introducing prima facies or assumptions or anything of the kind.
Well, I accept my lord's point. I'm not sure that anybody is suggesting, I'm certainly not, that there is some kind of presumption which needs to be rebutted. So you get first and second stage is satisfied, thereby one has a presumption of employment, which then needs to be rebutted at the third stage. I'm not suggesting that that is the right analysis. What I say, my lord, is that one gets force from the cogency, if you like, from the first two stages being satisfied. And that's, as it were, something of importance going all the way back to ready-mix concrete, because when one sees the third and fourth examples in this list, perhaps that helps a bit more. So the third example at E is a contract for work, but the individual is also obliged to provide some simple tools. And so his lordship says 3 lines into that example, notwithstanding the obligation to provide the tools, the contract is one of service. That obligation is not inconsistent. It is not sufficiently important to affect the substance of the contract. So his lordship is giving an example. He's trying to isolate particular points. But he's showing that you can have satisfaction at stages 1 and 2, and then a so-said counterpoint. Well, there's an obligation to provide the individual's own tools. Well, his lordship's saying that really just doesn't matter, because it doesn't change the substance of the contract. And the second example is of the same kind. The fourth example, second of this type, is the same essentially. Same contract for work, but the additional feature is to provide his own transport. And his lordship says, well, that's still a contract of service because the obligation to provide his own transport doesn't affect the substance. It's incidental to the main purpose of the contract. Whereas in the second example, the carriage contract is the essential part of the performance. That's what the contract is designed to achieve, carriage. Whereas example 4 is a contract for work, albeit the individual has to drive his own car while he's doing it. So my lord, what one sees from those third and fourth examples is, I would say, further support for the point that stages 1 and 2 carry with them inherent force. And obviously one can multiply examples and multiply counterpoint clauses in the contracts of employment by way of testing the issue. But one sees the essence of the structure, my submission, very clearly from there. The next case I wanted to show my lords on this subject is quasi. So it's the bundle 2 of the authorities at tab 24. That's page 477. And in the judgment of Lord Justice Elias, it's paragraph 8. And then 14. So I've shown my lords already paragraph 8 about the question of focusing on the contractual provisions, or as it's put later on in the paragraph, the employment relationship. At paragraph 14 of the judgment, his lordship, Lord Justice Elias, is referring to an earlier judgment of his own in the Employment Appeal Tribunal in a case called Stevenson and Delphi Diesel. And without detailing my lords too long about the history, his lordship makes clear that his mode of expressing the idea in Stevenson was too sweeping. He says control is not the only issue. Even when the work-wage relationship is established and there is substantial control, there may be other features of the relationship that will entitle a tribunal to conclude that there is no contract of employment in place, even during an individual engagement. And he gives O'Kelly and Ready Mixed as examples. Ready Mixed we've seen. O'Kelly, the reason why there's still no contract of employment, despite all the individual instances, is that there is no obligation from one engagement to the next on either party. And so it lacks, the overall arrangement, and that was what was an issue in O'Kelly, lacked the requisite element of mutuality. Even if each individual shift might have involved work-related mutuality, that wasn't the relevant issue in O'Kelly, where the individuals were trying to establish that there was a framework agreement which entitled them to be treated as...
That's also called what? Umbrella contracts, overarching contracts, global contracts.
Quite so.
Don't exist in those cases.
Well, because it depends on the purpose that the individual, the claimant, is trying to achieve. And the employment law purpose that was being sought to be achieved in that case depended on a relationship that was continuous as opposed to discontinuous. And so it really mattered to the conclusion. But what... And one sees that actually reflected in this judgment itself, my lords, at 12 on the other side of this page. Picking up what my lord just said a moment ago about an umbrella contract, from about halfway down to the end of that paragraph, referring to O'Kelly. This is exactly my lord's point. Now, the way it was put, if I can phrase it like that for the moment, in Weight Watchers, was also the way it was put in Wright and Aegis, which is tab 34 in bundle 2, page 683. This case involved two completely separate issues. One was status and the other was territorial jurisdiction, because the work was being done by an Australian national, albeit he was also a UK national, working in the Australian embassy in Kabul. So there was a jurisdictional issue which was resolved against the claimant. But there was a separate issue about his status, which he lost at first instance, but won on appeal, and it didn't avail him any because of the jurisdiction issue. But the point at hand is paragraph 14 about the third criterion being a negative one. It's put like that by Mr. Justice Langstaff without any separate reference to Weight Watchers. So it looks as though he's arrived at this conclusion independently. I'm conscious, my lord, that Wright and Aegis is an unreported case, and so one doesn't have a list of the materials to which the tribunal was referred. But one sees at 14 on page 691. He says the 3 lines down, the third criterion is in essence a negative one. That is, that the other provisions of the contract do not take a contract at which there is a mutual agreement to provide work for money, which is to be under the control to a sufficient degree to make one a master and the other a servant, outside the definition of a contract of employment. He says there may be situations of which Ready Mix itself was an example, in which, notwithstanding two conditions, 1 and 2, necessary for the contract of employment, the contract was not properly classified as such. Now, to answer my Lord Justice Peter Jackson's questions, I can't say to what extent there was adversarial argument on this point, but it was a disputed issue about the employment judge's approach to classification of the contract, which his Lordship Mr. Justice Langstaff was addressing in this part of his judgment.
The advantage of paragraph 14 of this judgment is that it's actually very close to the language of RMC itself, and it avoids the use of the contentious phrase prima facie.
Yes, I can see how, taken the wrong way, those words might lead one inadvertently into error, into thinking that you don't have to do much at the third stage. In any case, And that's certainly not my submission to my Lord. And
In terms of the structure of the test, you say that paragraph 14 of Mr. Justice Langstaff's judgment is correct.
I do say that, my Lord. And it expresses the same idea, albeit in different language, that Mr. Justice Briggs expressed in Weight Watchers. And in my submission, it captures, when one reads ready-mix concrete as a whole, what Mr. Justice McKinnon was getting at with his third condition.
I think it's very close to RMC.
Sorry, I thought my Lord was going to say it was very close to the adjournment, but it is as well.
No.
There is a sort of note of caution sounded by Mr. Justice Langstaff in the second sentence, where he says, I note that those are two positive requirements before a contract may be classified. I emphasise the word may as a contract of employment.
Yes, I accept that, my Lord.
No, I appreciate
Because it's important to understand that they're necessary but not sufficient.
it's not quite the same as a prima facie conclusion. I mean,
Strikes me as a much more neutral carrying forward of the RMC
yes.
language.
Yes, I mean, one gets.
Maybe the point is we shouldn't attribute too much weight to the phrases that one particular judge has used. I mean, that's what comes out of this, isn't it, really? Because in the end, the point is you look at, are stages 1 and 2 satisfied? Yes, we then look at whatever we have to look at to determine whether there is a contract of employment. And really, that's what has to be done, however prima facie or not prima facie. Any conclusion is at stages 1 and 2.
Yeah, quite so. And the third stage may in some cases be straightforward.
Yes.
Right.
In other cases may be extremely difficult.
Yes.
And some cases will fall in between. And that's a matter for the facts of the particular case.
Yes.
In some cases, it will be an important element. In other cases, the conclusions on 1 and 2 will make it almost a formality.
Yes, it all depends, of course, I accept that, my Lord. But what I would say, just in light of some of the questions that have been properly put, if I may respectfully say so, is that there is still an inherent point here about the force of the conclusions inherently about mutuality and control. These are not matters to be taken, as it were, lightly.
No, you said more than once they have inherent force.
And that is the submission about it, my Lord. That I appreciate that the third stage may override that inherent force, or it may not. It all depends on what the facts are to be considered at the third stage. But it's important not to lose sight in my submission of
Yes, and it also
quality, the nature of those.
This is part of the argument, but it also depends upon how forceful they inherently amount to on the particular facts of the case.
I do understand my Lord's point. I would say that in any case, positive
Bound to carry
conclusions
some weight.
carry a considerable degree of force.
Considerable. Thank you.
There were two other references I wanted to show, my Lords, just to finish off on this point, and I believe we could get through both of them before the conventional adjournment time. The first is auto claims in the Court of Appeal. And one sees that in the Supplementary Authorities bundle at tab 3. It's page 23. I'm sorry, my Lords, this in point of chronology is pre-Weight Watchers.
Yes.
And so it's more a question of answering my Lord's question earlier about what extent, if at all, had there been judicial expressions of a similar kind to that which Mr. Justice Briggs used in Weight Watchers. If one sees paragraph 68 in the judgment of Lady Justice Smith,
Page.
that's page 31 of the bundle, my Lord.
68.
Para 68.
Yes.
she's there dealing with the third requirement of ready-mix concrete. There should be no other contractual term which was inconsistent with the relationship of employer and employee in a contract of employment. And on the facts, she said the only possible term which might fall into that category, which was one which on the face of it entitled AutoClaims not to provide work. However, the employment judge had found that wasn't the true agreement. That the true agreement was that AutoClaims would provide work. So that was the end of that point. But it's all I mean to show, my lords, by taking the court to this paragraph is that in some cases, the only thing to be weighed at the third stage will be something of very little weight. And so the language of a prima facie affirmative conclusion in those circumstances is fair, but it's focused on the facts of the particular case. The last reference, my lords, is back to the regular bundles of authorities number 3, tab 43. So that's page 945. I know my lords are confronting this as a matter of the hearing that my lords presided over last week, but it is worth just keeping in mind in this context that as part of its judgment in Kickabout, the Upper Tribunal accepted the same approach as was stated by Mr. Justice Briggs in Weight Watchers. One sees that at paragraph 82, foot of page 964. And at the top of page 965, the metaphor that was used was that stage 3 does not proceed from what might be termed, quote, a standing start. And that's the Upper Tribunal's, as it were, metaphor for the point in that case. And then it's picked up again at paragraph 91. Once the Upper Tribunal had concluded that there was an obligation to provide work, and one had left out of account as essentially unimportant the lack of express provisions in the contract with the service company about holiday pay and so on. Then, as it was put, the balance shifts decisively as the remaining factors identified as pointing against the quote's prima facie affirmative conclusion given by the first two stages are, in our judgment, relatively slender. So one sees the language used in the context of a case where what is being put before the court at the third stage doesn't amount to much. And it's in that context that that phraseology is being, in my submission, correctly adopted. But I do understand my Lord's concern about using language that might lead other tribunals into error inadvertently. Perhaps at that point, it's a convenient moment to pause.
It is, thank you. Are you content with your rate of progress within the timetable?
I'm going to need to speed up, but I will do my best.
Very good. Right, we will resume at 2 o'clock.
All rise.